Hi, everyone. Welcome to the Rule of Law and Combating Gender-Based Violence Against Women and Girls virtual film festival. This film festival highlights the importance of combating gender-based violence and the role of justice, rule of law, and partnerships play for creating a sustainable peace. Our screening today is hosted in collaboration by the United Nations Team of Experts on Rule of Law and Sexual Violence and Conflict, the Office of the Special Representative of the Secretary General on Sexual Violence and Conflict, the United Nations Office of Rule of Law and Security Institutions, Department of Peace Operations, and Physicians for Human Rights. For today's screening, we will be sharing a short film on Kavumu in a few minutes. After the screening, our moderator, Augustine, will introduce our panelists and start off the question and answer period with a few questions that were submitted ahead of time, and then open the floor to all of you to ask the questions. Please feel free to share your questions in the chat throughout the event, and Augustine will relay your questions to the panelists. A short disclaimer, this film touches upon topics of sexual violence and rape of children, so viewers' discretion is advised. We want to thank you all so much for coming to really discuss this very important topic, and we hope you enjoy the screening of Kavumu. Thank you so much.
Thank you so much, Elizabeth. Again, good morning, everyone. Good afternoon and good evening to all joining us from around the world. Welcome to this session on the Rule of Law mini film festival, marking the 16 days of activism against gender-based violence. Today, we will screen the short video on the Kavumu case, a landmark moment in the Democratic Republic of the Congo, where a series of horrific rapes committed against very young girls were eventually exposed as a coordinated pattern of violence by a local militia. This case stands as a powerful reminder of what becomes possible when national authorities, civil societies, and international partners work together to pursue justice, even under difficult political and security conditions. After the film that will be displayed very soon, we will have a discussion with two exceptional experts who supported and analyzed this work closely. Then we will open the floor, as Elizabeth just mentioned, for your questions. Let's begin with the film.
Le document de ce journal nous emmène dans le sud du Kivu, en République démocratique du Congo. La région a été le théâtre d'une série de viols sur de très jeunes enfants entre 2013 et 2016.
Frédéric Batumike, c'est ce petit homme au milieu des prévenus. Ils sont accusés de violences sexuelles, d'une sauvagerie inouïe sur 46 petites filles. La plus jeune avait 18 mois.
Les viols se commettaient la nuit dans des maisons habitées où l'enfant était retiré de la famille du lit pour être violé, soit derrière la maison ou dans la broussaille, et par la suite, l'enfant était retourné à côté de la maison. Et donc, toutes les victimes étaient acheminées à l'hôpital pour être soignées de leurs blessures.
Donc la clinique donnait les soins médicaux aux enfants, faire un accompagnement psychologique, mais après, il fallait aussi assurer un volet de prise en charge judiciaire.
Et donc toutes les informations utiles aux enquêtes étaient consignées dans le certificat médical, et ce certificat médical qui nous était partagé.
Les victimes, avec l'aide de différents acteurs, la clinique de Panzi, la Physicians for Human Rights, avaient déjà saisi la justice civile plutôt au niveau de Kavumu et même au niveau de Bukavu. Mais malgré ça, il n'y a pas vraiment une avancée au niveau judiciaire.
C'est que vous faites face à un enfant qui a été enlevé la nuit. L'enfant qui ne parle pas, parfois un enfant de 6 mois, d'une année, 1 année et demie, cet enfant ne peut pas parler. Et donc vous ne pouvez pas lui dire qu'est-ce qui vous est arrivé. Et il fallait interroger les parents. Les parents eux-mêmes ne savent pas ce qui est arrivé parce qu'ils se sont réveillés, les faits étant déjà commis. C'était une très grande difficulté pour les policiers.
Donc il y a tout un tas de partenaires qui essayent d'agir, je dirais, chacun de son côté dans les volets qui les concernent. Mais pour faire avancer les cas, parce que ça semble être un cas énigmatique que personne n'arrive vraiment à expliquer, alors il y a cette initiative qui va se mettre en place pour dire non, essayons, au lieu d'avoir des actions qui sont non coordonnées, essayons de nous mettre ensemble puisque nous avons le même objectif.
La société civile a joué un très grand rôle. La société civile a mis la pression sur tout le monde, sur les acteurs judiciaires, sur les acteurs politiques.
On constate qu'il y a un point commun, c'est le mode opératoire. À chaque viol, il y a des saignements, donc des objets tranchants qui sont utilisés donc, pour recueillir du sang des enfants. Et dès ce moment-là, on essaye de comprendre qu'il y a une sorte de systématisation.
Vous montre que c'est l'un des cas. Ce sont des cas qui sont commis dans le cas d'une attaque systématique ou généralisée. Et là, on peut avoir plusieurs victimes pour un seul crime.
Et donc, de décider des changements, des stratégies dans cette affaire. Et notamment, à faire passer les cas du procureur civil vers le procureur militaire parce que l'on avait constaté que l'affaire comportait un élément qui pouvait faire en sorte que les crimes ne soient pas considérés comme étant des crimes isolés, mais des crimes collectifs, et donc passibles de qualification des crimes contre l'humanité.
C'est grâce au service de sécurité qui avait pu dénicher une jeune milice dénommée GBV, basée aux plantations Bishibiru, créées par Batumike.
Batumike est député provincial.
Immunité parlementaire. Il était protégé. Et donc, on ne pouvait pas intenter une action en justice contre cette personne-là sans qu'on soit rassuré que ses immunités lui soient enlevées, lui soient retirées.
Lorsqu'on s'est rendu compte qu'il s'agissait des crimes de la compétence de la CPI où la qualité officielle n'opère pas, nous avons directement signé un mandat d'amener pour le récupérer. Donc, nous nous trouvons devant un groupe dangereux et avec des armes.
On dit justement à des arrestations de près de 70 personnes.
Même Batumike, qui était considéré comme un petit dieu, a été arrêté et condamné. Donc, il n'y a pas d'intouchable.
En fait, c'est le premier cas. Ça ne s'est jamais passé en République démocratique du Congo. Et après ces arrestations, il n'y avait plus eu de crimes qui se commettaient.
Nous avons retenu deux sortes de crimes. Crimes contre l'humanité par viol et les crimes contre l'humanité par meurtre.
D'abord, les membres de la milice étaient très actifs et leurs familles constituaient une grande menace pour les victimes et témoins. Et donc, il fallait vraiment protéger ces témoins parce qu'il y avait une menace de mort.
Les avocats des partis civils avaient fait une demande, une requête donc, à la Cour en évoquant un certain nombre de mesures qui devaient assurer la protection des victimes. Parmi ces mesures, nous avons d'abord le fait que les enfants mineurs ne devaient pas comparaître directement et que des vidéos préenregistrées et filmées devaient servir pour leurs auditions. Le fait que les autres témoins notamment les parents, devaient comparaître protégés avec des robes cagoulées, par exemple, de bout en bout, et aussi avec distorsion de voix. Et ces victimes devaient comparaître pas directement face à face avec les bourreaux, donc mis en fait quelque part dans un isoloir, et avec la possibilité de garantir les droits de la défense. On ne donnait pas les noms de chaque victime. Chaque victime était identifiée par un code. Donc il y avait toute une batterie de mesures qui avaient été sollicitées auprès de la Cour.
Il fallait qu'on ait des éléments qui prouvent que Batumike savait que ces hommes commettaient ces faits, ces actes-là.
Il y a eu plusieurs types d'éléments de preuve qui ont été présentés, ce qui sont les témoignages. Nous avons aussi des preuves documentaires, donc nous avons des rapports médicaux, légaux, nous avons des rapports psychologiques.
Et également les rapports des Nations Unies. Il y a aussi des multiples rapports de la société civile et des ONG non gouvernementales.
Il y avait également traces électroniques. Tous les contacts, donc tous les téléphones des auteurs étaient exploités et le rapport était très important pour permettre aux juges de pouvoir comprendre comment étaient organisés les groupes, comment les groupes se communiquaient entre eux et que c'était important qu'on comprenne que c'est ces groupes-là qui commettaient les infractions de violences sexuelles comme crimes contre l'humanité. Et donc il y avait des preuves.
La Cour a conclu que ces personnes étaient tous complices. Elle les a condamnés donc sur base justement des dispositions du statut de Rome sur la complicité.
Que quelqu'un qui est couvert par des immunités soit poursuivi, arrêté et condamné. Et donc c'était exceptionnel.
En ce qui concerne les condamnations, sur les 20 prévenus, à l'époque, il y a eu 12 condamnations à la peine pénale à perpétuité pour crimes contre l'humanité par viol. Il y a eu 2 condamnations à 12 mois pour participation au mouvement insurrectionnel et il y a eu 6 acquittements.
Je crois que ça, c'est le message très très important. Si on avait considéré ces cas comme des cas isolés, on en serait encore à la situation où aucun auteur n'aurait été poursuivi pour ces cas. Parce que dès ce moment, le monde des responsabilités diverge un peu. Lorsqu'on le considère comme un crime collectif, un crime de masse, et donc comme un crime contre l'humanité, on a des modes de responsabilité qui peuvent permettre en fait de pouvoir responsabiliser les auteurs collectivement. Lors du procès lui-même, toutes les mesures de protection ont été prises pour que les victimes ne soient pas retraumatisées, pour les recueils des témoignages des victimes. On a évité que l'autorité judiciaire puisse directement interroger les victimes. Et on l'a fait par le truchement des psychologues qui sont spécialisés, n'est-ce pas, dans le travail avec des enfants et dans des situations qui concernent les affaires criminelles. Et en même temps, on a utilisé ces processus de vidéo, de télévision en circuit fermé pour permettre aux OPJ assermentés de prendre les dépositions des enfants.
Et cette approche nous amène à une prise en charge holistique. Toute action qui pourrait porter atteinte à la dignité, à la vie privée, à la santé et à l'intégrité physique de la victime doivent être évitées.
La dynamique de collaboration peut être un élément très déterminant pour solutionner des cas. Les moyens financiers qu'il a fallu déployer pour permettre les perquisitions, les arrestations, l'organisation des enquêtes, donc l'organisation des examens médicaux, légaux, l'organisation des auditions et la protection qui a été assurée pendant le processus.
Chacun a son rôle, chacun peut mettre la main à la pâte et on peut avoir de bons résultats.
Ce qui me semble important dans cette affaire du point de vue de la communauté internationale, c'est le rôle que peut jouer la justice nationale dans la prise en charge du contentieux des crimes graves. Je crois que la justice nationale peut jouer un rôle lorsqu'elle est renforcée en termes de connaissance du droit d'abord, parce que les magistrats qui ont siégé et qui ont enquêté sur ces crimes sont des magistrats qui ont suivi des formations grâce à l'appui des partenaires sur les enquêtes et la répression des crimes graves, ce qui leur a permis d'être à mesure de pouvoir conduire une enquête d'une ampleur complexe.
Au bout du tunnel, on voit la lumière et cette lumière-là, au lieu d'être étouffée, elle éclaire tout le monde et tout le monde voit. C'est la patience également et travailler sans lâcher les bras. Never give up.
Thank you for watching, and again, welcome to those who just joined us to the Kavumu case. I'm Augustine Mirimo from the Office of the Special Representative of the Secretary General on Sexual Violence in Conflict. After watching this film, I'm now pleased to introduce our two panelists. First, I would like to welcome Chloe Marnay-Baszanger, Director of the United Nations Team of Experts on the Rule of Law and Sexual Violence in Conflict. Welcome, Chloe. Then we have Karen Naimer, Director of Program at Physician for Human Rights, a global leader in using science and medicine to advance human rights, and a long-standing partner in supporting investigations and accountability to conflict-related sexual violence. Welcome, Karen. Chloe works focus on strengthening national and rule of law institutions to deliver survivor-centered justice in some of the most challenging contexts. Thank you both for joining us. We will begin with a short guided conversation and then open to the audience for questions. A question for Chloe, and that is related to the significance of Kavumu for national justice system. Chloe, in the film, we see how national prosecutors and military jurisdictions pursued a very complex case against a powerful political figure in extremely difficult operation conditions. From your perspective, what made this case such a turning point for domestic accountability for sexual violence in the DRC? Please, go ahead.
Thanks, Augustin, and very nice to have so many of you online today. We're really delighted that this conversation can reach beyond those that are with us in New York or with us in the field, and to be able to discuss with you. So I look forward to your question and a really interactive debate. But Augustin, to answer your conversation, I think you pointed it to some extent in the wording of your question. I mean, the Kavumu case is really a landmark in terms of harvesting the power that national justice system can have to hold perpetrators accountable for widespread sexual violence in fragile settings. And what I mean by this is that this case was really fully led by Congolese authorities. We saw in the movie, police officer, Mr. Bodelli, who was leading this. We saw the prosecutors, we saw the military judges, and they really took on that leadership to pursue a very influential political figure, also in a very difficult security context. And I think that's really important because the military court in Bukavu played a decisive role. It decided that, you know, no one was above the law, which sent a very powerful message, but it also really was agile in the way that it adapted some of its procedures to protect the children. And I think we saw a number of people within the film, you know, giving very concrete little examples about what it means to be truly victim-centered and trauma-informed in terms of pre-recorded testimonies, in terms of child-sensitive interviewing protocols, and also protection measures, since, you know, this was being carried out in a context where the militia, which was armed, was still active. Maybe the last point is how bringing together a multidisciplinary horde of actors played an absolutely critical role. So the Congolese institutions, you know, maintained their ownership and leadership throughout the process, but the success was really also part of that organization and structured partnership with civil society, which contributed to essential information as well as community access, but also to international partners. We saw PHR, we saw Trial, which provided very specific and technical support to being able to crack that case. And I think that really was what was truly a new methodology applied to this case, which allowed to move away from what maybe national courts are usually able to do, which is looking at domestic crimes, to international crimes, the ability to move away from isolated individual incidents with direct perpetrators, looking at international crimes as patterns of systematic sexual violence and a degree of command responsibility as well. So this case continues to influence reform and practice and how we work, certainly as the team of experts with national counterparts, but also in the DRC, it's become a reference point on how to conduct and to be able to build on those complex cases.
Thank you so much, Chloe, and much appreciated. Now turning to you, Karen, and my question is related to your experience working with very young survivors and their families. Karen, the film shows how PHR and other partners supported the work with child victim in deeply sensitive and proactive way. What were the most important considerations? And here I'm referring to either ethical, medical, psychological considerations when supporting the participation of such young survivors. Please go ahead.
Thank you. And I really just want to thank the team of experts and all the hosts for convening this really important discussion and highlighting the critical elements that really made the Kavumu case so successful and actually a model, as Chloe was just saying, for so many other cases that have come since. So I'm really delighted to be here. I'll just say at Physicians for Human Rights, we use science and medicine to document forensic evidence of human rights violations to support accountability. When we started partnering with clinicians at Panzi Hospital, police, lawyers, and judges in DRC almost 15 years ago, we collaboratively developed a range of tools and strategies to strengthen the collection and documentation of forensic evidence in sexual violence cases to strengthen survivors' access to justice, really by providing that critical technical support. So when the young survivors from Kavumu started presenting at Panzi in 2013, we were able to apply these technical approaches and strategies to gather critical evidence. And there were a number of crucial innovations that the film highlighted to support evidence collection, active engagement of young survivors, and critical victim and witness protections. And I just want to highlight 4 of them because I think they really stood out in the Kavumu case and have become models since. First is standardized documentation. Starting in 2012, PHR worked with our network of Congolese medical legal partners to develop collaboratively a forensic medical certificate. This form helps clinicians document forensic medical evidence of sexual violence in a standardized way that's admissible in court. The form helps clinicians gather probative evidence that informs investigations and prosecutions and provides judges with more comprehensive data to adjudicate these cases. So by 2013, Pansy clinicians were using these forensic medical forms to document each one of the Kavumu cases as they presented to the hospital. Because the forensic medical evidence was documented in a standardized way, the serial nature of the crimes and systematic patterns of perpetration became really clear and enabled the Justice Task Force that eventually emerged in 2014 to argue that the crimes perpetrated should not be viewed as more than 42 plus isolated cases over time, but construed instead as a single case of of crimes against humanity, as you heard in the film. Once the case was deemed a matter of mass crimes, military justice was able to assume jurisdiction and the case was able to move forward. So in effect, the standardized medical documentation actually enabled the case to advance. Second, forensic interviews with child survivors were conducted only by clinicians in order to avoid re-traumatization. Given the very young ages of the child survivors, clinicians and police worked really closely with survivors and their families to ensure child-centered, trauma-informed protection strategy that really safeguarded the best interest of the child. So during the pretrial period, the investigation team, and this really was so innovative. So like Chloe, I want to call out the national actors in DRC who really pursued this. They set up a secure child-friendly space for each child to be interviewed by a forensic doctor alongside a pediatric forensic psychologist to capture what happened to the child, to document physical injuries and psychological harms each patient sustained. The interviews were conducted with the parents' informed consent, but also critically with the child's assent, so that the interviews were recorded and then securely preserved. These interviews, carried out in a friendly environment, help the children feel much more comfortable to be able to recall the events and share what happened to them. And notably, police officers observed the interviews in real time in a separate room through closed caption television, allowing them to obtain the relevant information for their investigation, but without needing to re-interview the young survivors. So that further prevented re-traumatization. Third, the court allowed the recorded interviews of the child survivors to stand in for their live testimony in court. As the prospect for a trial approached, there was so much anxiety around having these young girls serve as witnesses in court because there was a high risk the justice process would further traumatize them. So another innovation that was introduced was that the judges agreed to refer to the recorded interviews in lieu of compelling the young survivors to appear as witnesses in court. This, to support due process, the defense had full access to the recordings, the transcripts were made available to the defense, and they were able to raise objections or questions to the judges in closed-door hearing. But this approach spared the child survivors from being intimidated by the court process, including facing the militia members sitting in the dock and the hundreds of spectators from the community watching in the public gallery. And fourth and finally, security and confidentiality. The court took additional special protective measures, as you heard in the film, for witness and victim protections, pseudonyms, closed sessions, protective screen, head-to-toe covering, really critically, voice modification device to shield the voices, disguise the voices of those who were testifying, and there was psychotrauma support for sitting with the witnesses to reassure them as they gave their testimony. This really was the first time a Congolese court allowed this full slate of special protective measures to be used. And it marked an important precedent for more comprehensive survivor-centered, witness-centered responses to sexual violence crimes. And I really do just want to call out the medical, law enforcement, and legal stakeholders from DRC, because they really should be recognized for the innovations of the Kavumu case, and their pioneering innovations are now being replicated in so many other cases in DRC and beyond.
Thank you so much, Karen. That's much appreciated. And thank you both. We will now take questions from the audience, and please feel free to ask about the case, lessons, and or for other contexts and any aspect of the investigation, evidence, and even survivor-centered approach that was highlighted in the film and for which you would like to address our panelists. I have here a question from the audience, actually, related to prosecution and immunity. Someone asked to both you, Chloe, and Karen, since the crime were committed by Congolese nationals against Congolese nationals on Congolese sovereign territory, with suspect hiding behind diplomatic immunities, how come the diplomatic immunities were not simply removed by the government? Please, over to you, Chloe and Karen. We start by Chloe.
So maybe just to say, I think here we're not talking about diplomatic immunity as such. It was we're talking about the chief perpetrator was a parliamentarian from the regional level, and so he was covered by his immunity as a parliamentarian. But I think just to kind of, it's not diplomatic in the sense that it wasn't somebody from a foreign state being protected by diplomatic immunity as such. It was more his own kind of functional immunity as a parliamentarian within the national system. That being said, the way that, and I think this is pointed into some of what was said in the movie, the way that this was able to actually be tackled was to actually look at the fact that it was not a common crime that was being perpetrated, but in that case, the fact that it was analyzed as an international crime due to the serial nature of the fact allowed to look at how we proceeded with immunity in terms of lifting immunities that do not cover international crimes. And so that's what's explained in the movie by one of the protagonists, is that at the moment that they realized that it wasn't common crimes that they were dealing with, but it could be construed legally as an international crime and a crime against humanity, they were able to look at it from a different perspective, and the immunity of the parliamentarian did not apply. I think we need to also call out, as Karen said, the courage that it took for the national institutions to actually, not just the technical nature of understanding that aspect of the legal construction of the case, but also the political courage it took to the national and regional judicial authorities, police and prosecution, to decide to go ahead with tackling such a prominent character of the regional community, who not only had that prominent political role, but also, as we heard in the movie, still had armed actors operating on his behalf. So there was really also not just the legal understanding, but the political and personal courage that it took to the national authorities to do this. I don't know if Karen wants to add something on that.
Yeah, I think you covered it. I really want to just highlight two pieces, just to really reinforce. The last point that you just made, Chloe, is so critical. While these crimes were taking place between 2013 and when the arrests were finally made in June 2016, there was an enormous amount of terror on the ground in these communities, in the community. There were the crimes were taking place. Remember, it didn't all take place at once. It was the serial nature meant every few weeks, every few months, there was another brutal case, which was terrifying for the families. And then there were many civil society members of the community who were trying to speak out about what was happening. And 2 civil society activists along the way were murdered. So this further sent a chill for everyone working on these cases. Eventually, when it became clear that it was a very powerful militia that was carrying out these crimes, and the head of the militia was a member of provincial parliament, I really also want to reinforce Chloe's point about the courage that it took to really pursue the case, but also pursue his removing the waiving of his immunity. And I do want to call out, it wasn't simple, actually. No. This was a step that required engagement from Kinshasa, from the national government and parliament. And when the arrest took place in June of 2016, it took about a year for that immunity to be successfally lifted. So it was not a simple process. But as Colonel David Bodelli said in the film, they never gave up, and that was very powerful. And so that it was once the immunity was lifted that the case was actually able to go to trial in November 2017. But that was a really critical turning point for us to be able to see justice advance.
Wonderful. And we take away the motto, never give up. Turning back to both of you, and this is on lessons for other contexts of conflict-related sexual violence. Chloe, the Kavumu case is now often referenced globally as a good practice. What are, for the audience and all of us, the key lessons from Kavumu that you believe are the most relevant today for countries emerging from conflict or grappling with spread CRSV?
Yeah, Kavumu is definitely a beacon in the work that we do to try to tackle justice for conflict-related sexual violence. And, you know, I think it's rare to see in any jurisdiction such exemplary way. And I think Karen has highlighted a few, but let me come back on a few things. You know, from our perspective at the team of experts, you know, we see 5 key replicable lessons that we can take, and that we are taking, in fact, into other contexts, including, you know, most recently in Ukraine. You know, the first one is the survivor-centered approach and trauma-informed approach. I think Karen highlighted that very well in terms of, you know, what were some of the protective measures that allowed to have adequate participation from, you know, the victims into, and, you know, the concerned parties into the trial. And I think it's important to point out that, and you saw it in the images, you know, this does not need and does not require very sophisticated or very onerous means to actually be able to conduct such victim-centered approach. Meaning, you know, you don't need to be a well-tooled court, etc. You can do a lot of things with quite little, but yet have that protective impact, and, you know, guarantee the safety, guarantee the environment that allows victim to feel like they can come forward and speak without being re-traumatized. So I think, you know, that survivor-centered piece would be the first lesson. And this is something that we, for example, we carried out an assessment in Ukraine recently in terms of how can we boost victim participation into that. And, you know, we were guided by some of what we saw occur in the Kavumu in the DRC. I think, you know, some of the lessons of Kavumu, even Colonel Bodelli, who now works in Central African Republic, is actually taking those and, you know, using that in the work he's doing in the Central African Republic. So it really is estimating. The second important lesson concerns evidence. And again, I think, the movie looks at that quite pointedly, and Karen reminded us about a few of those as well, which is, conflict-related sexual violence often are some of the most difficult cases to prove in court, particularly in the context of conflict where, getting to victims, accessing crime scenes is not done in the same fashion as you would do in domestic common crime investigations. And that means that you really require to bring not a single type of proof, but the success hinged on the investigator being able to bring together multidisciplinary types of evidence to prove the crime, whether it was the forensic and medical evidence Karen elaborated on, pattern analysis, child-sensitive statement, but also information from civil society and community actors. That is, the comprehensive nature of the evidentiary approach is a model for other contexts. And this is discussions that we've had, again, with prosecutors from different contexts in which we work. The way that you may be able to prove rape in your national domestic context and under your national law may need also to be tinkered with. And I think we saw some of the procedural adjustments that were done in terms of, video recording as opposed to having witness and victim testify live during the audiences. So, those are all things that we are taking to other contexts to try to work with other counterparts. The third important element is the coordination aspect and the structured approach of partnerships between national partners, prosecutor, police, medical experts, and civil society. So at the national level, it's not one judicial actor that will make the success. It's really the galaxy of those actors working together, interacting together that can make it, and the ability that they have to be supported by international partners, be it, civil society, international partners like PHR, like TRIAL, by the UN. We saw that the task force that was created included a lot of the component of the mission, of the UN mission, and some funding, obviously. I mean, none of this comes for free. So I think, this is also a call to say that, and that's my last lesson learned, is that, justice is possible, even in fragile settings, even in conflict settings, and institutions do not need to be perfect to deliver results. We need trained investigators and prosecutors, we need survivor-centered procedures, we need technical support, and we need political backing. So I think, Kavumu really reminds us that justice for sexual violence is not something that's theoretical, it's practical, it's achievable, and it starts with strengthening and trusting national institutions while centering on survivors at every step.
Thank you so much, Chloe. Turning back to Karen, the film refers to the use of innovative practices in collection of evidence that enable the active participation of young victims and their families. And you have pointed out in your previous remarks and answers some of those. Can you tell us more about these innovations as we are talking about lesson learned and best practices and how they were implemented?
Yes, thank you. And actually, I really want to endorse every point Chloe just made. I really appreciate. I think those are some really critical lessons from the Kavumu case. And Augustin, just to build on your question and add to Chloe's answer, I think I'd like to also identify not only some of the innovations, but lessons learned from the case that, in addition to what Chloe shared. So we've seen how some of these successes and lessons learned from Kavumu have carried forward to inform many other cases and other processes. With respect to standardized documentation, that really was critical. Before the Kavumu case, Pansy clinicians were discreetly using that standardized medical intake form. But the Kavumu case showed the power of that documentation, and actually it enabled clinicians, Congolese clinicians, police officers, lawyers, judges, military and civilian legal stakeholders to advocate for that form to be nationally adopted. And in 2022, I would say in large part thanks to the success of the Kavumu case, in 2022, Congo nationally adopted that medical certificate. So it is in principle available for use and should be used, mandated to be used across the country. So that's a major development because it actually helps to support clinicians and other national actors to better support survivors by capturing comprehensive evidence. The form was also featured as a global model in the UK's international protocol for the documentation and investigation of sexual violence and conflict. And that form has been adapted for use in other countries like Iraq. And there are ongoing discussions in Ukraine that where that's being pursued as well. The other major innovation that I think the Kavumu case was really emblematic in showing success is that non-forensic, that is to say forensic science clinicians, can play a pivotal role in conducting forensic exams and gathering forensic medical evidence. Many jurisdictions mandate that only forensic doctors, a very specific kind of doctor, can collect and document forensic evidence. But actually, all clinicians, doctors and nurses, can and should be trained to do so. It's really a false belief that only forensic medicine specialists are capable of producing high quality forensic medical legal reports. We saw that in the Kavumu case. In fact, in most countries where medical resources are limited, more clinicians need to be trained and empowered to gather forensic evidence because that's the only hope survivors have for gathering evidence and obtaining meaningful access to justice. So along with Chloe's call for funding and support, I really do think that's another critical area that requires real support and engagement and advocacy to ensure that clinicians and healthcare workers in these communities are equipped to be able to serve survivors in the most comprehensive way. And the last, but I think one of the most critical elements of the successes employed in the Kavumu case that have really become a model to the rest of the world is building good practices for engaging children in accountability processes. Children are disproportionately affected by war and other situations of mass atrocities, either as deliberate or incidental targets. But there's a lack of prioritization of crimes affecting children, in large part due to a reluctance of clinicians, investigators, prosecutors to investigate these violations because they're really worried about re-traumatizing children. But children can also be harmed when they are excluded from the justice process. So the answer isn't to shut out children because a justice process can accommodate them. Instead, as we learned and saw in the Kavumu case, we have to adapt our judicial processes to accommodate child-sensitive approaches. And we've seen how the Kavumu case has informed the development of a whole body of international and other national processes and policies that have taken these lessons into account. So the ICC OTP's policies from 2023 on gender-based crimes, crimes affecting children, and the 2024 policy on slavery crimes articulate global standards that have incorporated lessons from the Kavumu case. The Murad Code for Survivor-Centered Good Practices also elevates these principles, and PHR has also, and other organizations have launched global communities of practices of experts who are working in national, local levels and global levels with children and are really trying to help build and expand the body of knowledge of how to manage these very complex, sensitive cases involving children. So these are just some additional examples about of how the lessons of Kavumu have really expanded beyond this case to incorporate other cases in DRC, but also in many other national geographies and global best practices.
Thank you so much for the answer, Karen, and much appreciated. One of the participants just share a reflection to basically make sure that the best practice and lesson learned from the Kavumu may be to be considered a reference for the training to investigators, prosecutors, and judges. And if this can be a part of the curriculum to be rolled out all over the missions to maximize the availability of resources, including mandatory stock of forensic inventory to all missions. This is just a reflection from a participant. And another question is basically to understand the motive that determined the commission of this crime. I think the Finn mentioned about the motivation behind the Kavumu case from the perspective of the militia. And I think your question and insight really helped to understand beyond what was shared. And I want to take this opportunity to thank you both Chloe and Karen for your reflections, and thank you to everyone who joined us today and for your meaningful questions. The Kavumu case, as we just see, reminds us that justice is possible, even in a fragile environment, when national authorities, civil society, medical experts, and international partners, all partners available on the ground, work together. When survivors, including the youngest, are protected and supported. When evidence is carefully collected, analyzed, presented with rigorous and compassionate manner, when resources are available, as we are just mentioning. It also shows the extraordinary courage of Congolese prosecutors and judges who pursued this case despite political pressure and security risks, ensuring the perpetrator were finally held to account. We hope today's conversation deepened our understanding of how rule of law institutions can deliver meaningful justice for survivors of conflict-related sexual violence, and in a complex and difficult environment that, like in the Congo. Thank you again to all for your participation, and we look forward to seeing you at the next screening, which continues tomorrow and the day after tomorrow. Thank you and have a wonderful ending of day.